Good day, and we wish you a very warm welcome to today's webinar. This is our first webinar focused on sanctions, a fast-changing and topical area where we have seen so many recent developments in our shipping and insurance sector. It's really fantastic to have so many of you tuned in.
So let's start with some introductions. My name is Britt Pickering, and I'm the Claims and Legal Director here at Shipowners Club.
And I'm Camilla Slater, and I'm the Head of Legal at the club, and together we are the main point of contact for sanctions.
So in a moment, you'll see some slides which will guide you through today's webinar.
So let's start with some basics. What are sanctions? Where do they come from? And who imposes them? Governments and multinational bodies impose economic sanctions to try to alter the strategic decisions of state and non-state actors that threaten their interests or violate international norms of behaviour.
So if I was to summarise what in my experience would be the three most pertinent general points on sanctions, they would be that they are fast changing, increasingly focused on shipping and insurance spheres, and that they are sometimes unclear as to how they actually apply and against whom they might be enforced. Part of the reason for this lack of clarity is that sanctions originate from multiple sources. They target a variety of entities, and they can sometimes be in conflict with each other. In short, they affect different people in different ways.
Here you can see an overview of the major sanctions regimes affecting our shipping and insurance sector. Let's start with the US. To quickly understand the US position, it is important to grasp the distinction between US primary and US secondary sanctions. Briefly speaking, primary sanctions target US people and US entities, as well as US origin goods and transactions that take place on US territory or in which the US can assert its jurisdiction. Secondary sanctions, on the other hand, target non-US people and entities. When I first entered the sanctions sphere, I found myself wondering how it is that the US can effectively implement their own sanctions regime beyond the US shores. I found this quote of Jack Lew, the then US Treasury Secretary in 2016, very helpful. He said that secondary sanctions are generally directed towards foreign persons. These measures threaten to cut off foreign individuals or companies from the US financial system if they engage in certain conduct with a sanctioned entity, even if none of that activity touches the United States directly. In other words, the US government is able to flex its muscles by relying on the might of the US dollar and the international reliance on the US banking system. As Britt mentioned earlier, sometimes there can be a lack of clarity in the way in which sanctions legislation is enacted. Just to add some further complication to the US sanctions situation, occasionally it can be unclear whether US sanctions are intended to have secondary sanctions implications.
Moving on now to the EU. This is particularly important to us at the club as EU insurers, and also to many of you who operate in the EU. EU sanctions impact where there is a connection with the EU. So in reality, any vessel under EU member state jurisdiction, and also any EU person, EU company, or EU business done, whether inside or outside of the EU territory. It's important to understand that EU sanctions can still impact you, even if you are not yourself directly within their scope. For example, even if you are not an EU national, you may be practically prevented from working on a project if your EU national client or counterparty is caught by EU sanctions. It is also important to appreciate that while some of the EU and US sanctions mirror each other, often they do not.
Last but not least, national sanctions. By these I am referring to sanctions legislation in your own country of domicile. It is important to be aware of these and how they might apply to you.
Sanctions can be targeted and applied in various ways depending on the intent of the sanctioning body. One of the key methods used is to impose sanctions on individual parties, which are then named and listed, for example on US and EU sanctions lists. The aim, of course, being to restrict others from dealing with the listed parties. You may often hear reference to the term SDN in this context. This is a reference to a particular US listing of a party as a specially designated national. US people are prohibited from dealing with SDNs, and sometimes SDN status also attracts secondary sanctions, meaning, as just discussed, that non-US people are also prohibited from dealing with them. In the sanctions sphere, it's of course never quite that simple. You may have heard of OFAC's so-called 50% rule. OFAC is the Office of Foreign Assets Control, part of the US Department of Treasury. OFAC administers and enforces economic and trade sanctions, and the 50% rule means that any entity that is owned 50% or more by one or more SDN is itself then treated as an SDN. The EU also lists a number of parties who are subject to an asset freeze. This means that EU people cannot make funds available directly or indirectly for the benefit of asset freeze targets. The good news, though, is that the US and the EU publish searchable databases, so you can easily check whether parties are listed.
Importantly, sanction screening is only part of the picture. It is equally important to check the activity or trade that you intend to engage in. Is it a restricted activity for you or your counterparties under any applicable sanctions regime? When I say counterparties, I mean clients, contractors, co-venturers, and so on. To explain further, it is perfectly possible for an activity to be lawful but to be prohibited because, as Britt has just mentioned, listed parties are involved. On the other hand, there may be no listed parties involved, but the activity itself could be sanctionable. There are various ways in which the differing regimes and listings can present themselves. To bring this point to life, for example, a Russian vessel owner may be able to trade with a Syrian entity that is subject to an EU asset freeze because Russian interests may not be directly affected by EU law. However, an EU insurance company would have difficulty in paying claims monies directly to such an asset freeze target as a result of the asset freeze. The situation can become complex when there are multiple parties and various trades involved. It's important really to just think of the whole picture and always exercise caution.
So we've just spoken about parties and activities, but there are also practical considerations to take into account. It is very common to face banking problems once you stray into the sanctions arena. Banks often apply very strict compliance policies, which can easily be triggered. By way of example, in our experience, banks may be unwilling to make payments related to a sanctioned country, even if the trade itself is not prohibited, and even if there are no sanctioned parties involved. Banks, of course, are particularly sensitive as they have been subject to hefty fines for stepping out of line.
Over the next few slides, we're going to focus on the international sanctions regimes where we see the most impact on shipping and where we here at the club receive the majority of queries. This overview is not intended to be comprehensive for each of these regimes, but we will just give you a snapshot of the key points. This might be a good moment to remind you that we have far more information on our club website. Simply click on the link to sanctions on our homepage.
Starting with the headline country, Iran. The key points to remember here are that these nuclear-related sanctions against Iran were partially lifted in 2016 as a result of the JCPOA deal, and this is often known as the Iran deal. Prior to January 2016, draconian sanctions were in place, which effectively prohibited all engagement with business connected to Iran, and that included insurance. Following diplomatic efforts, the Iran deal was agreed between Iran, the EU, and the P5+1 countries. On implementation day in 2016, it was confirmed that Iran had complied with its nuclear-related commitments. This resulted in a partial lifting of US sanctions, and EU sanctions were also lifted. For example, key activities affecting our members that were now permitted were trades in oil and gas, transactions in the energy, shipping and port sectors, and insurance. The US position was more complicated because primary sanctions persisted, thereby continuing to prevent US engagement with Iran. However, secondary sanctions were largely lifted, thereby allowing non-US persons to re-engage. Critically, in November 2018, of course, the US pulled out of the Iran deal and reimposed secondary sanctions. This means that there is once again a risk of sanctions being imposed against non-US people. This includes a risk of sanctions imposed on the club and members who breach sanctions by carrying out Iran-related activities for which we give cover. for example, oil and gas related activities. There are some permissible activities that do not attract secondary sanctions risks, for example, carriage of some agricultural products and consumer goods. However, the situation is such that it is effectively impossible for us to support any members working in Iran because, as previously mentioned, all banks are highly risk averse to making payments with touch points in sanctioned countries such as Iran.
You may well wonder why it is that North Korea appears on this slide, since in the shipping world, North Korean entities are not commonly seen as trading partners. However, as we shall discuss later, North Korea is one of the countries that is under intense scrutiny by the US and the UN and others as an area where suspicious maritime-related activity is taking place and where ship owners and operators may become inadvertently implicated. North Korea, as you will be aware, is subject to an intensive international sanctions regime. You will see on the slide some of the activities of concern.
Moving on now to Syria, there are some key points to bear in mind. Both the EU and US apply trade sanctions against the government of Syria, and there are a number of designated Syrian persons and entities to be aware of. In terms of activities, there is a particular risk when it comes to providing illicit financial support to the government of Syria via the transportation of petroleum to state-owned and operated ports. As an insurer, we must be very mindful of these restrictions, as those who facilitate insurance in respect of these shipments are at risk of sanctions enforcement.
Moving now briefly to Venezuela. This has attracted much media focus in recent times, and once again, the shipping world is heavily affected by the sanctions imposed. Earlier this year, the US escalated its Venezuelan sanctions regime, and there are now significant consequences for those wishing to engage with Venezuela. US persons are prohibited from engaging in any transactions with the government of Venezuela, its agencies, or any entities in which it holds 50% or more greater interest. This includes PDVSA. As we mentioned earlier, it can sometimes be unclear upon whom a sanctioning country intends to impose sanctions. The US position with respect to Venezuela is a perfect example of this. The position with non-US people was far less clear as it developed than it was for US people. That said, there is a risk to non-US persons of designation as an SDN if they operate in the Venezuelan oil sector or provide material assistance to the government of Venezuela. The effective designation as an SDN is likely to result in exclusion from using the US dollar currency and banking system.
That now finishes our overview of the major sanctions regimes affecting our shipping and insurance sector. As we now move towards the final section of this webinar, we will explore how key developments in the last 12 to 18 months have significantly heightened the risk of being caught up in sanctionable activities, which could ultimately put your business at risk.
It will have been clear to you from the discussion so far that there has been an expansion of sanction regimes in recent times. There has been a significant increase in parties listed by the US. Listings, in fact, appear to be the tool of choice for the current US administration. In April 2018, the US government announced a bold set of designations, including 40 Russian oligarchs, officials, and related entities, including major publicly traded companies. In November 2018, at the time of the reimposition of secondary sanctions, 700 additions to the Iran SDN list took place, the largest single set of sanctions designations by the US. In January 2019 came the renewed interest in Venezuela with the listing of PDVSA that we have just discussed. Importantly, non-US shipping companies are by no means immune to this enthusiasm shown by the US for listing. Most of our audience would have noted the recent designation of 2 COSCO shipping entities, as well as the designation of 4 other Chinese companies and several individuals. The increase in listing has extended not only to shipping companies, but also to vessels. This is in part, at least, a consequence of the US and others stepping up surveillance and scrutiny of vessel activity in high-risk areas. Over recent months, the US has also issued strong warnings to the entire maritime community against sanctions-busting activity related to Syria, North Korea, and Iran. These warnings have come in the form of advisory notices. The notices highlight deceptive shipping practices deployed in order to evade sanctions. One key area of focus is AIS monitoring. AIS is an onboard system that continuously transmits a vessel's position, speed and course, amongst other things. The advisories warn of the risk of vessels turning off AIS in order to mask sanctions-busting activity. The notices also warn against other deceptive techniques, such as vessel identity tampering and STS activities, that's ship-to-ship activities, concealing the origin or destination of cargo. Significantly, the US goes further than simple warnings. Ship owners, operators, insurers, and others in the marine industry are directed to identify red flag activities for further investigation and to take active steps to guard against risks. For example, due diligence and vessel AIS monitoring. It is clear that the United States will target those in breach of sanctions. The OFAC advisories name several vessels said to have engaged in sanctionable activity. These are not officially listed, but there are significant commercial and practical consequences for their owners and operators as a result of the publication of these vessel names. The US has recently become particularly strident in its messaging on enforcement. The Syria advisory, for example, states as follows: the US government will aggressively target for designation any person who provides support to the regime, for example, by facilitating exports to or imports from the government of Syria. To sum up the current position, through the recent advisories, it is evident that there is an increasing focus on the shipping industry. The spotlight is very much on owners, operators, charterers, and insurers. Recent designations and advisories further illustrate that the US will target foreign ship owners and vessels involved in sanctionable trade, and it is a clear message that those operating in the shipping industry must exercise utmost caution. No one should be in doubt that if they become entangled, knowingly or unknowingly, in sanctions busting, then they risk stringent enforcement measures.
As we reach the end of our webinar, let's just consider for a moment how to protect yourself against sanctions risks. A written compliance program is important for identifying risks, assigning procedures, and delegating responsibilities within your company. There is an expectation that companies will have a compliance program in place, and it's important to check the position expected by your governing authority. From a US perspective, OFAC have indicated that a strong compliance program will be helpful in defence of any persons who face a sanctions violation. Indeed, OFAC have published their own guidance, which is called a Framework for OFAC Compliance Commitments. This lists 5 essential elements of an effective economic sanctions compliance program, including, of course, management commitment and training. This OFAC framework is a recent publication which can be viewed on our website, and it gives more information there than I have just outlined.
So now let's explore a little bit more with regard to due diligence. What steps are necessary to protect your position before and during engagement? Every company will have a different approach to due diligence based on individual risk appetite and the sanctions regimes that are in place. Checks on all parties and activities are so important. Continue also to review the circumstances and think about the consequences if there is a change in the regime. For example, additions of parties to a sanctions list or a change of status. A party may become listed during your course of dealings, or an activity may become prohibited. Ongoing screening is obviously vital.
Here at the club, we sometimes see that owners have encountered difficulty when they have chartered their vessels on either short or long-term charters, and the charterers have engaged in sanctionable activities. The difficulty has been worsened because owners have not perhaps sufficiently understood the nature of charterers' intended activities, their areas of trade and so on. Further, that they have not made use of the added protection that comes by using appropriate contractual clauses. BIMCO have 2 standard charter party clauses that can be used to protect against sanctions risks. These are the Sanctions Clause for time charter parties and the Designated Entities Clause for time charters. The objective of the Sanctions Clause for time charter parties is to provide owners with the means to assess and act on any voyage order issued by a time charterer which might expose the vessel to the risk of sanctions. The test is one of reasonable judgment by the owners in determining whether the risk of imposition of sanctions is a tangible one. The designated entities clause for time charters applies in respect of persons or entities, including vessels, that are listed. The clause sets out a requirement for owners and charterers respectively to warrant that they are not designated entities, and where used for a voyage charter, charterer's warranty extends to cargo interests. The warranty continues throughout the currency of the charter party. The clauses are available on the BIMCO website and they're currently under review, so check back regularly on that site for updates.
So we have now nearly reached the end of our webinar. We hope you have found this useful and that you're encouraged to find out more. As mentioned earlier, the importance of keeping up to date with developments cannot be stressed enough. Due diligence is absolutely key. And we have got a wealth of information on our website, so please do visit, and we're going to be more than happy to help with any of your queries. So we're going to open now to a live question and answer session. So please send in your questions and we'll be more than happy to answer those. We may not have time for all the questions today, but we'll certainly answer what we can now, and then we'll follow up in writing on those ones that we haven't yet been able to address. So whilst we're waiting for those questions to load up, I thought, Britt, it might be useful if we might mention a few aspects, perhaps which we haven't quite touched fully on today, but relate to the topics that we've covered, and that are really relevant, I think, from a club cover perspective. Perhaps some of the issues that we see here in our sort of day-to-day dealings when we're helping members and brokers with their queries. So I suppose one of the situations which we come across will be when members will approach us in the first instance and say that they intend to engage in certain activities or certain trades. And it's at that point, I suppose, that we are able, as a club, to kind of give some initial guidance, aren't we?
And I think actually that that prior notification and reaching out to the club is so important for us, and we always welcome that. Coming to the club is also it's not rather a substitute for a member doing their own due diligence, but of course we can help where we can.
Yes, absolutely. The members have to always do their own checks, not least because, of course, they'll be more aware of the regimes and the laws that affect them. Absolutely. But we can certainly give guidance on where we can, and it's helpful to know in advance.
Absolutely.
We can give pointers on club cover as well. The other sort of area I think that sometimes I see that we find issues, and these ones are where we have perhaps claims incidents, and sometimes they can be what I call almost entirely innocent, entirely innocent situations. For example, a vessel that may have come into collision with another vessel, and perhaps that vessel is Iranian or is perhaps owned by an SDN, as we mentioned earlier. And now the very fact that perhaps that might just happen in the Singapore Straits or some other sort of, I suppose, low risk area of the world, but the very fact that the vessel has hit that other vessel that's sanctioned, tainted, if you like, creates difficulty, doesn't it?
Absolutely. And we have had that. Also, it occurs sometimes when there is an illness or an injury on board a vessel which necessitates some kind of repatriation or medical assistance. And often that can happen in a particularly difficult area of the world in relation to sanctions. And those issues, again, I mean, categorised as kind of innocent. And we can help members with that. And sometimes it can be lengthy and difficult, but we can get to an end to it.
Exactly.
We have.
And sometimes the lengthiness is just purely because of those practical problems that we talked about earlier, the practical banking difficulties.
Dealing with the banks.
Dealing with the banks and dealing with the situation. It's not that the owner, of course, couldn't have prevented the situation happening, but we have these sometimes legal problems, but a lot of the time kind of practical difficulties. But again, that's why I think it's so important that we all kind of try to keep up to date with developments, loosely speaking, because these situations could really happen to anybody in the shipping industry. And I think before we move to the questions, which I think are loading up, I think one other important point from a club cover perspective that might be interesting to mention is just where we've seen owners having chartered their vessels out to charterers. And you, of course, mentioned this in the context of the BIMCO charter clauses.
Yes, very important.
Because sometimes we can see the importance of having done that work in advance to sort of map out what the charterer's intentions are with the vessel.
Really important to know what the charterers are doing, what the trade is, and where trading area is, and also to keep up to date throughout the course of the charter, which could be a long-term charter, and sanctions seem to change quite frequently.
Yes,
so it's
exactly.
keeping up to date and knowing what's going on and using the right clauses.
Yes.
Also, I think just before we go to the questions, I think there may be some merit in actually talking a little bit about the differences between being listed on an advisory,
yes,
and being listed as an SDN.
Yes, no, true. That's a point that we mentioned earlier, because we have seen situations where vessels have been annexed and listed on an advisory, and sometimes people have asked us, well,
what does that really
what
mean?
does that mean exactly?
Yeah.
So interestingly, when you read the advisory, these seem to be listed as vessels that are suspected as having engaged, or seem to have been engaged, as the US tell us, in these sanctionable activities.
Yeah.
But really no information is given as to exactly what, where or when these vessels were doing what they were doing. And so therefore that becomes quite difficult to kind of counter that information. And there appears to be, well, as far as we're aware, and of course we're not US lawyers, but we don't believe that there is any actual way in which you can have that situation rectified. Absolutely. If in fact you can test that.
But the practical consequences of being listed on an advisory or being an SDN are kind of quite similar. I mean, once you are listed on an advisory, it's very difficult to then trade your vessel,
yes.
Sell your vessel,
yes.
Really do very much at all.
Yes,
with
exactly.
your vessel.
It becomes an extremely difficult situation, hence our reference earlier to the kind of the significant practical and commercial consequences, and the reason to be really, really careful about what the activities of your vessels are, because if owners and so on are not watching, certainly others will be watching. Absolutely. So you don't want to find out from somebody else.
And I think that's the point actually. The advisories are a real, they really highlight the fact that people are watching.
Exactly.
And I suppose in a nutshell, ignorance is no defence.
Exactly. Okay, so we have the questions now to answer. If you are watching the recording of this, may I just mention that you will now see the questions and answers will be in a text form. Otherwise, if it's live, you'll be able to see those questions and answers live. So that's it from us. So thank you very much.
Thank you.
Thank you and goodbye.
Thank you very much.